All right, we have a new motion from Attorney Weinstein where he is looking to help get this case wrapped up. It's called the Motion to Time Limit State's Case Due to Prosecutorial Unpreparedness and Inefficiency, Undue Delay, Waste of Time, and or needless presentation of cumulative evidence. That is the title of this motion, y'all. So let's get into it. The defendant, Diamante Kendrick, by and through his undersigned counsel, without waiving any other rights to which he is entitled, files this motion to time limit state's case due to prosecutorial unpreparedness and inefficiency, undue delay, waste of time, and or needless presentation of cumulative evidence, stating the following. As this court has broad discretion to exercise reasonable control over the presentation of witnesses and evidence, the court should use that discretion to prevent this trial from stretching indefinitely and beyond the reaches of time due to the state's unpreparedness and inefficiency. The state has put and continues to put this court, these defendants, and these 16 jurors through an arduous, tedious journey. The court should put an end to our forced march, even as the state will likely contend that we should blindly trudge on in the trust that the next months will be different, that the state will develop the speed and efficiency of our finest Olympic athletes, and that the finish line of their snail-like marathon is in sight. At this point in time, this honorable court has borne witness to the state's unpreparedness and lackadaisical attitude toward any type of diligent approach to moving in a definite fashion towards a conclusion. But why should the state have any need to move with deliberate speed? The state returns home to their friends, family, and loved ones at the conclusion of each day. The state lives their lives, goes to work, and gets their paychecks no matter how long this trial proceeds. Meanwhile, for Kendrick and the other defendants, every day is Groundhog Day. But instead of waking up to Sonny and Cher, he wakes up to the cacophony of Rice Street and the ritual of heading to court. The United States has explained the critical role of the trial judge in a criminal case. Quote, our cases have consistently recognized the important role the trial judge plays in the federal system of criminal justice. The judge is not a mere moderator, but is the governor of the trial for the purpose of assuring its proper conduct and of determining questions of law. A criminal trial does not unfold like a play with actors following a script. There is no scenario and can be none. The trial judge must meet situations as they arise, and to do this must have broad power to cope with the complexities and contingencies inherent in the adversary process. To this end, he may determine generally the order in which parties will adduce proof. His determination will be reviewed only for abuse of discretion. The judge may refuse to allow cumulative, repetitive, or irrelevant testimony. If truth and fairness are not to be sacrificed, the judge must exert substantial control over the proceedings. End quote. So that was all a quote from the Supreme Court. The state, after originally proposing a witness list of over 700 witnesses, has a list over 100 witnesses it still intends to present at trial. What specific evidence the state intends to use with each respective witness remains unclear. A very generalized description of subject matter to which each witness will testify has been provided. It appears he wants to say has not been provided there. I'm not sure. No end to the state's case in chief is in sight. This is simply untenable for the remaining 16 jurors or the defendants who remain jailed without bond, and the presentation of another 100 witnesses by the state would cause undue delay, would be a waste of time, and would amount to needless presentation of cumulative evidence. As put so succinctly by the Third Circuit Court of Appeals, quote, courts need not allow parties excessive time so as to turn a trial into a circus. After all, a court's resources are finite and a court must dispose of much litigation. In short, the litigants in a particular case do not own the court. End quote. That was from the Third Circuit Court of Appeals. Likewise, the prosecution here does not own this honorable court. This honorable court has broad discretion on the presentation of evidence and should limit the introduction of duplicative and unnecessary witnesses by the state. As noted by the Georgia Supreme Court, quote, OCGA Section 24-6-611A2 provides the trial court with broad discretion to exercise reasonable control over the presentation of witnesses and evidence to avoid needless consumption of time. The Fifth Circuit, the predecessor to our 11th Circuit, has also recognized the ability of a trial court to limit the number of fact witnesses at a criminal trial where those witnesses' testimony would be cumulative. Furthermore, this court can limit evidence under Rule 403 of our state's Rules of Evidence. Quote, relevant evidence may be excluded if its probative value is substantially outweighed by the danger of unfair prejudice, confusion of the issues, or misleading the jury, or by considerations of undue delay, waste of time, or needless presentation of cumulative evidence. Georgia Code Annotated Section 24-4-403. Thus, there is also a basis under either Rule 611A2 or Rule 403 for this court to exercise reasonable control and discretion in placing a time limit on the state's case to prevent undue delay, waste of time, or be a needless presentation of cumulative evidence. Quote, it has never been supposed that a party has an absolute right to force upon an unwilling tribunal an unending and superfluous mass of testimony limited only by its own judgment and whim. In exercising its reasonable control over the presentation of witnesses and testimony, Kendrick also urges this court to consider the ramifications of the present pace of trial and its impact on the jury, the case, as well as defendants. While there is no doubt that the new court is moving this case along at the fastest pace possible, giving the court's meritorious recognition of the limited recognized right of the state to present its case in the manner it deems best, the prospect of another 100-plus witnesses leads to several undeniable conclusions. This trial will last well into 2025 if the state is permitted unlimited time to present its case. Courts outside of Georgia and the 11th Circuit have recognized the impact on a jury of a lengthy trial merit consideration. For example, as the 7th Circuit has approvingly quoted, quote, exceedingly lengthy trials lead to reduced concentration and recollection of events on the part of all participants, particularly witnesses and jurors. In very long cases, exhaustion may diminish everyone's performance. The quality and representative nature of the jury may be reduced by the fact that many citizens, often the most competent, are unable or unwilling to take time to sit for cases lasting weeks or months. In Warner, the court also notes that jurors become overwhelmed by the volume of evidence and numbed by its repetitiousness. Their attention flags, their minds wander. The witnesses, there were more than 100 in the trial of the two defendants, get mixed up in the jurors' minds or forgotten. The profusion of exhibits makes the documentary record unintelligible. The impressions created by the closing arguments are likely to wipe out everything that went before. Jury comprehension has been found to diminish after a mere 20 days of trial. Finally, and not meaning to belabor the point, the court in Warner wisely notes, so now imagine jurors' mental state after 6 months, bearing in mind that memory loss and psychological or cognitive problems of jurors in a super long trial compound the first problem, the difficulty of recruiting competent jurors for protracted trials. A less intelligible trial is heard by a less capable jury. The longer the trial, moreover, the likelier jury misconduct becomes. The jurors become bored, impatient, irritated. The judge's instruction against discussing the case before the jury retires to deliberate becomes increasingly irksome and likely to be disobeyed. While the state puts on its case, witness by witness, Kendrick and the other defendants sit in jail, their lives on hold, the clock ticking on their lives, second by second, minute by minute, hour by hour, day by day, month by month. Meanwhile, the risk of a confused jury unable to comprehend a years-long trial only grows. Wherefore, Mr. Kendrick respectfully requests that this honorable court to place a reasonable time limit on the amount of time that the state has remaining to put forth its case in chief. So there you have it. That is Mr. Kendrick's motion filed by his attorney, Doug Weinstein. Everybody, let me know what you think. I mean, I'm sure everybody's going to say probably the same thing, that this case has been taking way too long, and that how's the prosecution going to call another 100 witnesses? So, but let me know in the comments. And if you want to sit back, relax, as I always say, and watch some more content, we're going to shoot right into a replay of our previous content that we came up with, that we compiled based on the state's unpreparedness. So you got some extra time, sit back, relax, and we'll shoot right into it.
Anyone, are we ready on anything right now?
And so that the court knows what I'm doing, I overheated. And so I had to wait.
By which you mean your laptop overheated?
I do mean my laptop.
So yesterday, the YSL trial continued, and the majority of the day was a lot of back and forth about evidence. Now, we did have one emotional outburst from Max Shart and then from Doug Weinstein about the unfairness of the trial and about another ex parte meeting that took place before the June 10th meeting. There was actually a June 7th meeting, and the transcript for that one came out. So you can find that online. Kat Knott Williams has a full reading of that transcript, so search that up on her page. But aside from that, yesterday was mostly about evidence. The one takeaway that you get watching yesterday, many people kept saying in the comments that the state just does not seem prepared. So what we're going to see in this video is a few instances where the state was just unprepared. After 2 years with this case, they're still unprepared. At least that's what many people are commenting. And you'll even see the judge come to a point where she says, is anybody ready to do anything? She ended court early yesterday due to unpreparedness, is at least the way I saw it, because they did not go to 5 o'clock as previously planned. So let's get into it.
But anyway, with regard to, does that make something said that is inconsistent in a prior inconsistent statement? And the state can provide me the law on that. But I think there are times when either an I don't remember or an I don't know or a, well, that was a lie, can still form the basis of making something a prior inconsistent statement. So, but
And Your Honor, I'm going to let Ms. Hilton speak specifically as to the law on factually what Mr. Copeland did say. What he said was, I don't remember anything that I told the police. I keep telling you, I don't remember anything. But if they say I said it, then I said it.
Yeah, I think what they're talking about is he also at certain points said, yeah, I absolutely said that, and it was a flat out lie, and I'm paraphrasing, but that is what they're talking about, correct?
Okay. If that's what they're talking about.
Is that what y'all are talking about, Mr. Sharp, Mr. Steele?
Yes, Your Honor.
Yeah, so that's what I would like for y'all to address.
Your Honor, we believe based on two positions, OCGA 24-6-621, which be impeachment by contradiction, as well as a prior inconsistent statement, in both that statement, I said all that I said, but it was a lie, or I was trying to finesse my way out of being locked up, would lay the grounds of still allowing the prior inconsistent statement to come in.
Okay, and 24-6-621 is the
Impeachment
by contradiction, and 24-6-613 is essentially prior statements, right?
Yes, Your Honor.
So what I'd like is some case law that represents the proposition that you are asserting, okay?
Yes, Your Honor.
All right. And I don't want it just simply quoted out of a horn book. I would like the actual case law.
You're right. If you can give us a moment, just because
Okay.
we need to.
I mean, y'all, when I told you a week and a half ago that I wanted to be going through Mr. Copeland's evidence, y'all had 10 days or more to get ready for this. So I don't know what y'all thought we were going to be doing, but yes, I'd like to hear it. So if you need a minute to get me the law, go ahead. At him. I don't know when he's going to come in, but all right. So as a part of all of the work y'all are going to be doing before the 5th, that's going to be part of what you need to do.
And not just for him, just so that.
No, yeah, for everybody, for your next 30 witnesses, and then for your next 30 after that.
And so if, not trying to tell the court how to use the court's time, but if during.
I'm open to suggestions since what I've come up with so far isn't working.
What I can do, what we can do as a prosecution team, over the next, however amount of time the court wishes to allow us, is to identify with respect to each of the witnesses that are co-conspirators. I know that there are several. We can, and that it will be coming up in the next batch of 30 witnesses. So we can identify, just to the court and the defense, those people, and begin looking at the portions of their statements, their respective statements, that we would anticipate needing to use, as opposed to using the whole thing.
Okay.
And so we should be able, over whatever amount of time the court gives us from here forward today, to go through and come back today with a chunk of statements for each of those people.
Okay.
If not all of them.
Okay.
Some of them.
I like what I'm hearing there, that by the end of today, she have done that for all of them. Yes, I like that.
Judge,
Yes.
I said it, so
You did say it.
There we go. But I not overshot.
You might have overshot. All right. Well, hey, if you can even do it for one, that'll give us something to work on. And I thought you said you could do that before the end of today. Okay. So anyone, are we ready on anything right now? And so was there an order at some point or a direction from the judge to tell the defense which statements you believed to be co-conspirator statements that led to this supplement? Yes. Okay.
I'm looking for it.
Okay. I mean, if there was, that's all I need to know. So yes. So, okay. Now tell me what other statements you believe to be co-conspirator statements and why they should come in now when you were ordered many, many months ago to tell the defense what they were.
They are included as part of the jail calls and the wiretap.
Okay. So they have them.
Yes.
They just haven't been identified as, hey, we think this is a co-conspirator statement. We intend to use it.
Yes.
Okay. Well, sure. Well, I mean, I shouldn't say sure. Sure, you can try to, whether you're successful or not, I don't know.
I understood. So when they say they've been provided, they have not been identified in any way, shape, or form. There are thousands of jail calls involving dozens of people.
Yeah.
There are about 3,000.
I think you've said enough. I understand. Them provided in discovery, not identified as here are what we believe to be co-conspirator statements. Thank you. That was kind of what I thought when she said you have them in discovery. All right. So I would imagine that the discovery in this case is beyond voluminous. And at some point in a trial in this day and age, you know, how it's supposed to not be trial by ambush anymore. It's supposed to not be trial by ambush. And I'm not saying you're trying to ambush, but at least as of now, really well before now, you should have identified. I think this is a co-conspirator statement. And honestly, you should have identified out of the God knows how many rooms full of boxes of discovery, here's what we're actually going to use. So to the extent you haven't done that, I've already told you you're going to be doing that by telling us very specifically as to each witness, here's the evidence I intend to use. But that's still weeks down the road. So if you know, well, let me put it this way. Whatever co-conspirator statement you know of right now, let's stand up and let's share it with the rest of the people here so that they can then tonight look at it and say, here's why it's not. Okay? And for anything that you don't know of right now, you need to go home tonight and huddle together and figure out what else there might be. And I will consider whether I'm going to let that in or not. And then if I do, potentially, we'll have to hear as to each of the alleged co-conspirators why it is that you either have or can establish through admissible evidence that they are in fact a co-conspirator, or not in fact. That'll be for the jury to determine, but there's a preponderance from which I can determine. Okay? All right, so who do you know of right now?
Your Honor, hold on 1 second.
Okay. She said, give me 1 second. But yeah, I mean, I know it's a big courtroom and there are a lot of us, so we all need to try to remember to speak into the mics. So maybe the state can, and you're pretty loud, Miss Love, but maybe pull that mic down so it's a little closer to all of y'all.
And so that the court knows what I'm doing, I overheated. And so I had to wait.
By which you mean your laptop overheated.
I do mean my laptop. Okay. And I was
because I've told y'all not to overheat anymore.
So that's what's
okay
happening.
So can you say those for people again louder so Mr. Harvey can hear?
Yes, Your Honor. The jail calls, the jail calls of the persons that I have in my hand that we're reviewing are jail calls of people who are currently on trial or who were on trial and entered a plea.
Okay.
So I don't think that that counts for what Mr. Harvey is talking about in terms of co-conspirator statements. In other words, for instance, I have Mr. Kendricks, Mr. Stillwell, Mr. Nichols, jail calls that we had under review by the team who was working on that. And that we've identified calls from that we intended to use.
If I may respond to that, if it's Mr. Nichols' phone calls, the kid has been in jail for a couple of years, number one. Number two, those are his statements. I'm entitled to those under the discovery statute. And if they're just looking at them now, 2 years later, you should, without any question at all, exclude those. I mean, this is...
Okay.
Come on,
so,
later.
It is my understanding that everything that my understanding based on your representation to me earlier today in court, that everything that you intend to use as a co-conspirator statement has been provided to the defense in discovery. Is that correct?
Correct.
Okay. And so what we're doing now is y'all asked that it be identified which are going to be co-conspirator statements. So it's not that you don't have it, it's that it is yet to be identified as a potential co-conspirator statement. So with regard to your objection about not having it, you have it, it sounds like.